Sean Combs' defense team says they reviewed the tapes. Yes, the alleged sex tapes. And they claim it proves Combs is innocent of his criminal charges. Time to break down this major update with acclaimed criminal defense attorney, Bradford Cohen. All right, quite the update in the Sean Combs case we got to talk about. More specifically, the Sean Combs criminal case out of New York, charged by federal prosecutors with sex trafficking, prostitution, racketeering crimes. The trial currently scheduled for May 5th, 2025. Now, so much of this case has been in the shadows, right? And that we don't know exactly what the evidence is per se, who the witnesses will be, the identity of the alleged victims, all of the key events, times, locations. We may get more information in the months and the weeks leading up to the trial, but right now, we got something big we got to talk about. So Sean Combs' attorneys have filed a letter, filed it yesterday, we're talking about it today, where they are asking the court to order the government to electronically produce some very key evidence in this case. What? The videos of the freak-offs. You remember what these are? The prosecutors allege that Combs would intimidate, threaten, and lure women into extended sex acts with male sex workers using force, threats, or coercion. The freak-offs that Combs filmed and recorded these freak-offs. Well, the reason the defense wants this electronically produced, the reason they want copies of this, and they need the court to step in, is because under the current protective order that has been put forward in this case regarding how evidence will be viewed and disseminated, the video evidence is available for inspection only. Now, according to the defense, federal prosecutors, they refuse to produce that over to them, but Combs' lawyers write, quote, "Having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented, but thoroughly enjoyed herself." And we believe victim 1 to be Cassandra Ventura, Diddy's ex-girlfriend, who first filed that initial sexual assault lawsuit against him back in 2023. But the filing goes on to state, moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much as a hint of coercion or violence. Far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. Now, before we go any further, I need to bring in renowned criminal defense attorney to the stars, Bradford Cohen, who's represented celebrities like Drake, Lil Wayne, Kodak Black. Okay, so happy to have you here. I got to get your thoughts on the defense's description of these tapes. Now, we haven't seen the tapes, but this is the defense's description and characterization of these tapes. Your thoughts?
I think it's interesting because, from the very beginning of this case, I was saying, I think that the original tape showing the violence against Cassie, I think the original tape was leaked by her team to show that she is a victim and not a willing participant or a co-defendant. So I've been saying that for a long time. So to hear this, that, okay, we've seen these 9 videotapes and these 9 videotapes kind of back up what we've been saying the whole time, that it's consensual sex between adults. It's an interesting thing to say, because I think that the videotapes are going to show that Cassie probably was engaging with another individual. The videotapes are probably going to show that it wasn't a hidden camera, maybe that she was making faces or saying something to the camera that confirms that it wasn't a hidden camera or someone's talking on camera. All those different things definitely help his case. Is it a smoking gun, as we say? No, probably not a smoking gun, because she's going to still say, listen, I was still under the control of Sean Combs. He was physically controlling me. He was mentally controlling me. That's going to be where she goes with this whole thing. And that's where that tape of violence comes in, to show that, yeah, it might have looked like I was doing these things on video, that I was a willing participant, But in reality, I knew if I was not a willing participant, then something else would have happened to me physically or mentally.
That is exactly what I wanted to ask you about, is about how the prosecution is going to use these tapes. Because the defense in their letter, they describe victim one in these videos as, quote, happy, dominant, completely in control. They write there is no evidence of any violence, coercion, threats, or manipulation whatsoever. There is no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. So, Bradford, the government has been very specific in what these freak-offs are and why they are illegal, why it's not just group sex, but what makes it illegal. What are they going to say that these tapes show? I mean, doesn't it have to have some element of violence? Does there have to be drug use? Is it just proving that sex workers are in those tapes? Is that sufficient? You might be right that this is just one piece of their overall case, that it's not a smoking gun. But I feel like there has to be more in the tapes to show evidence of pressure or threats. Otherwise, the prosecution is basically saying, and correct me if I'm wrong if this doesn't sound right, she may look like a very active, willing participant, but don't believe what she's saying, what she's doing. Maybe that's the case, but you can see where it gets complicated.
Like I said, by no means do I think this is any good for the state, if it is the government, if it is exactly what they're saying that it is, if it depicts everything that they're saying, if the defense is right and it depicts these things. By no means is it good for the state, for the government. Is the question really becomes, how are they going to use those tapes? Are they using the tapes? Obviously, she's going to have to testify that she was under physical and mental abuse, and that's why she participated in these things. Whether or not a jury believes that is going to be a very big leap. But do I think that's the only evidence they have? Probably not. If they're really, if the government is the government in the Southern District of New York, I can't imagine this is what they're hanging their hat on if it's what the defense describes. It's like one of those things that when you have a weakness in a case, the government has to decide how they're going to use that. My guess is they're going to use it to show that there were sex workers, that these sex workers were paid. I would imagine that they have the sex workers that are in the video to come in and describe what was going on or what happened before they went on tape, whether or not they had drugs or alcohol or anything else, whether or not Cassie had drugs or alcohol, whether or not there was a discussion between Sean Combs and Cassie before the tape started. So
Right.
I think that the tape is going to be one portion of it, but the testimony of either the sex workers that were in the video and or Cassie is going to kind of tie it together. That's my guess.
By the way, if the tape shows sex workers, is that not just in and of itself transportation to engage in prostitution, the third count that he's facing? It's a federal charge. It's a serious charge. It's not as serious as racketeering or sex trafficking, but if there are sex workers in those tapes and Sean Combs and victim one, presuming it's Cassandra Ventura, are with these sex workers, does that look like a straight up conviction on that charge, or am I wrong?
You're not wrong. The issue becomes whether or not a jury really wants to convict on those things. When you have cases with you have pimps involved and you have living off the funds of prostitution and things of that nature, where there's money being exchanged and it's a large sum of money, where the individual who's making money off of the prostitution, that's kind of like usually where you see federal cases go. You don't see a lot of federal cases where it's a John who hired a prostitute and they're having sex with someone they know or a girlfriend or a boyfriend, whatever it is. It's very unusual. So again, it's going to come down to the jury. Is the jury going to buy the fact that these feds are bringing a case? If they can't prove anything else and their case starts falling apart, is the jury going to say, well, he paid $2,000 for this guy to come to Miami and have sex with his girlfriend, and the girlfriend was a willing participant? That's to me, it's a hard sell.
I want to also move on to something else. You talked about the jury. They write in this letter, the premise that freak-offs are inherently dangerous shows that the government seeks to police non-conforming sexual activity, and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. And the defense also says that they reviewed photos that victim one allegedly sent to Sean Combs, and they say it appears to reflect, quote, entirely consensual sexual activity. Bradford, how much of this trial is going to be the jury sitting there going through sexually explicit photos and sexually explicit videos and trying to determine whether or not any of this is consensual.
I think it's going to be a large part. I think that
Let me just couple it. Or is it the fact that the tapes exist, right? If Sean Combs had been recording this, that in and of itself shows this kind of, nefarious intent that he was using it as collateral, as blackmail against victim one if she ever came forward. So how much of it is it going to be them looking at, to see if this is all consensual and what's going on versus, hey, the fact that this stuff exists, that's enough.
See, the problem that they have with the fact that this stuff exists, that's enough. What the defense is saying is that all this stuff was taken from Cassie's phone, Cassie's computer. She had a copy of it. So they're going to have to now say, okay, well, we seized his stuff and it was on his computer, it was on his phone. The defense is saying that he didn't have possession of this stuff, that it was all Cassie's possession. So depending on where the video was found, how it was found, if he had a hard drive with all these videos in it, sure, they can say like, oh, he was hanging this over her head or he tried to, blackmail her with this. But again, you can't just have just that in itself. You would need texts or phone calls or emails, something to back that up where he's threatening her saying like, hey, if you do this, I'm going to release these tapes, which doesn't sound like it makes any sense because if they had these tapes, think about this. If the defense had these tapes or Sean Combs had these tapes, when the tape came out or when the accusations came out that she was not a willing participant in this sex, you don't think those tapes would have been leaked? Like,
he would have gotten in a lot of trouble if he did that, right?
Well, before the charges were even filed, when she said when she first hit him with the civil complaint, and in that civil complaint says she was not a willing participant, she was not involved in these things, all these different kind of accusations in that civil complaint, you would at that point say, what are you talking about?
He settled with her the next day. And if you're him, I don't want to release these videos of me, my private sex life. He probably didn't want to.
No, but there's a way you could leak it to make sure her version of events was questioned, right? It's just like I said, just like with the video that was leaked, and I think it was leaked with the blessing of the Southern District of New York, because normally when you're an attorney and you're representing a victim in a crime, you don't just release things or leak them. And I don't know for sure.
You're talking about the CNN video. You're talking about the CNN video where Cassandra Ventura was beaten by Sean Combs.
Correct. And the video is horrible. I mean, no one's going to say that. Horrible. And there's no person on the planet that's going to say, oh, there's a redeeming quality in that video. There's something in that video that helps the defense. There's nothing in that video that helps the defense. It is horrible video. And that was the goal, is to, in my opinion, is to show how horrible the video is, how horrible a guy Sean Combs is. And because he's that horrible, we can then believe the next thing is that he forced her to have sex with these prostitutes.
So you're right. In the letter, they write the recordings also directly refute the allegations that Mr. Combs kept these videos as collateral. And again, that refers to the allegation that Combs was keeping these recordings to protect himself against anybody speaking out. But as lawyers say, these recordings were not on Mr. Combs' devices. They were not seized from his homes. Rather, victim one kept those videos on her own device for years, produced them to the government herself. That's their characterization. I mean, I'm curious, the defense says, hey, after the raids, we found other videos that he had in his possession. But here's what I wanted to ask you about. So there are lines in this letter that are redacted. They are blacked out. Is that for graphic reasons, or is that to protect victim one's privacy, or maybe the privacy of others?
It could go either way. So I don't know if it's just because it's graphic. Generally, when you're writing these letters to the Southern District, to a judge in the Southern District, you're not blacking things out because of graphic nature. You're usually blacking them out for some sort of privacy right or something that the judge already ruled on. What I think is interesting is this move by the defense, in my opinion, is genius, right? Because there's an order that says, hey, you can't disseminate any of this stuff. You can't leak it to the press. You can't talk about it in the press. So putting it in a motion, putting it in a letter kind of circumvents that by saying, hey, listen, judge, this is a filing. If the government wanted to seal that filing, we sent it over to the government. We gave them a copy of it. We sent it over to you. And if there's some sort of issue with that, then they should have moved to seal it right away or called Chambers to say, hey, let's not post this and let's not have this on the record until we have a discussion of what should be redacted. But they didn't do that.
Let me just clarify that. So the prosecution, in response, just filed a letter. And they're not directly responding to what the videos do or do not show, or whether or not Sean Combs has a right for these videos to be produced to him. And we haven't even gotten to that argument yet. And it seems like they're going to file a response to that at a later date. But the prosecution argued that this defense letter violated the protective order that was being put in place by the court, that under the protective order, no portion of the videos should have been filed on the public docket without being filed under seal, or without the defense first conferring with the government as to the designation. And they say neither occurred. And instead of conferring in advance or redacting all of the content related to the videos, they say that this letter from the defense blatantly violated the protective order because it left unredacted descriptions and characterizations of material that was designated attorney's eyes only. They argue this threatens the privacy of victims. They're asking the court to remove it from the public filing and have it be refiled with redactions. You're saying the prosecution might not have a strong argument there?
No, and the bell has been rung. What are you going to do? You're going to refile it and cross some stuff out? It's already out in the public. We already know what's in those videos, and it's not like the problem that I have with this. And I always say this. It's like you're not discussing what's in a video, but at trial you're going to see the video. There's going to be people in the pews that are going to be able to report on what's in the video. So when a court says yes, we have to redact, we can't file certain things. And to me, that always means you can't file the actual document. You can't file the actual video. I'm not going to give you, a portion of the video where I'm going to attach it to a motion and you have a clickable link. Those things are what I believe the court usually orders. A motion and a order, or a motion and a letter describing what's in a video in our own terms and saying, like, this is why we need the physical video. To me, I don't think they have a very strong leg to stand on with this. I don't think that the judge is going to say that they violated that order, because I think they have a very good argument. I hate when prosecutors, and they do this a lot in the government, they say, oh, you can come to our office and review this. You can come to our office and review that. I don't want to come to your office to review it. I want the actual document. I want the actual video on a hard drive or whatever it is, because I want my people to look at it. I want to see if they can enhance things. I want them to examine certain background to it. So whenever they ask that, that's always suspicious to me, and I don't like it, and I don't think the judge should allow it.
I want to just ask your opinion about something else. So in the letter, the defense writes, these recordings corroborate what witnesses have told the government, namely that victim 1, and then the rest is blacked out, although it seems like they're saying that these witnesses and recordings allegedly proved something about victim 1 that is helpful to Sean Combs. Right, Bradford? I mean, witnesses, they're saying witnesses have provided evidence that might hurt victim 1's claims?
Listen, the fact of the matter is that the big discussion here is whether or not it was consensual or not. And I'm sure they have sex workers that were like, listen, to me, it didn't look like she was under the influence. It looked like it was consensual. I have no idea. I can guarantee you they have witnesses that have said that. Now, do they have witnesses on the other side that say, oh, she might have taken drugs before, or he was bossy, or he made her do this or made her do that? Sure, I'm sure they have witnesses that say that too. So, whenever a defense puts forth something and says it's corroborated by the evidence, obviously they're not going to say what also hurts them. So, I do think that there's going to be witnesses that are going to say it was consensual. They were in a very long-term relationship. I can't imagine that there wouldn't be victims that or alleged victims that would come forward, or alleged prostitutes that would come forward and say, oh, I definitely had sex with her against her will, because that would make them look stupid. I just think this is a very sticky wicket that the prosecution gets themselves involved in when they make all these wild claims during bond hearings and all these things and these promises, and then all of a sudden the case starts to come out and it's not what they promised. And that hurts their case. It hurts their credibility. And I guarantee you there are potential jurors that are watching this.
And if they are, then during the voir dire jury selection process, they should admit that and say, yeah, I watched Law and Crime. I know this case very well. I can't sit on the jury. Now, let me ask you this.
You would hope so.
Yeah, well, look, we like the viewers nonetheless, but that's a separate question. Anyway, let me ask you this. So the defense, going back to the idea of they say we are entitled to copies of these videos. So they say the federal rules of evidence support the production of these videos. And more specifically, they cite Rule 16 of criminal procedure. And there is a provision that says upon a defendant's request, the government must permit the defendant to inspect and to copy data that is within the government's possession, custody, or control, and that is material to preparing the defense. And here they argue that the videos of the freak-offs are material because that's essentially the prosecution's central point in their case, the freak-offs. And they argue that the government hasn't presented enough of a reason to withhold the videos because it's not child pornography, it's not classified information. They say there are other ways to ensure that victim one's privacy rights are secured. But tell me which way you think Judge Arun Subramanian's going to rule on this, Bradford, because on one point you could say, look, and talk to me about whether these are Brady, they have, this is a Brady right, this is a due process right. Talk to me about all that, about the defense's perspective. They have a right to all of this information to prepare for the defense, whereas the prosecution will say, listen, you're dealing with very sensitive material. This is not a lawsuit where a plaintiff has come forward and voluntarily submitted herself for cross-examination. It's our case. We're bringing it. She's a key witness. This is going to be private information about her. Look, we're just now accusing the defense of violating the protective order and sharing details they shouldn't have. They should only have a right to view these material in an inspection format. We'll give them an opportunity to review it, but we shouldn't have to be able to produce copies of it because it's a real danger of that. So talk to me about both sides here.
All right, so a lot to unpack. So
Yeah.
let's start with this. Number one is she brought a civil claim, right? This would have been discoverable in the civil action, but for it being settled, right? So number one is they would have had an entitlement to this just in the civil matter, but we're gonna put a pin in that for a minute. You go fast forward, now their main argument to me is gonna be, listen, Judge, you see how they filed this letter? This letter, it went right against your order. They disclosed things they shouldn't have. They shouldn't be trusted at this point, and that's why we can't give them a copy. That's what they're going to try and hang their hat on. My guess is that this letter was a violation of his order, and as such, they shouldn't be entitled to the actual physical copy. If it's me, I'm the judge, I turn over the physical copies of everything, and with a strict order that nothing is to be released, it's for attorney's eyes only, etc., etc. But the long story short is they have a right, they should have an entitlement to get all the discovery, all the facts, all the video, all the recordings. Like I said before, I always file motions whenever they say, oh, come by our place, you can inspect it. I don't want to come by your place. I don't want to inspect it. These are not my pals. These are not my friends where I'm coming over to watch, a football game. I want my discovery. I want it in my office. I want my experts to review it. I want them to see if there's any issue with backgrounds, if there's any issues in the video, if there's different things that I can't see with my naked eye that my experts might be able to enhance. So all those things can't take place if I just go to their office with my expert and inspect it on it. And not only that, when you go to a state attorney's or a governmental office to inspect, I never trust them not to overhear what I'm saying, what I'm looking at. What if I'm reversing it? I'm playing a certain part of the tape. I want to see, number 4. I want to see number 5. They usually know what I'm trying to look at, and then they can try and figure out what my defense is. To me, it's one of those things that is just natural that they should turn over everything to the defense. Now, put on top of that a layer of Brady, where the defense is saying, and for your audience, Brady information is information that helps the defense that the government or the state would have to turn over. And it is material, and it goes to the heart of the defense. And that's what they're saying this is. They're saying it is Brady material. So why should I go and have to go to their office to inspect a video that I consider Brady? It just doesn't make any sense. My opinion is, prior to this letter, I would say this is a no-brainer. The judge, says, hey, listen, turn it over. It's for attorney's eyes only. This letter adds a little bit of a speed bump because the judge might find that, hey, listen, you guys didn't cross the line, but you came very close to the line. And that worries me about turning these videos over. But what I've seen from this judge is that he's extremely fair. He thinks about things. He reads the law. He's knowledgeable about the law. And my opinion is he's going to turn these over. The government's going to be required to turn over all the video, all the audio, and he's going to say attorney's eyes only.
All right, well, we shall see. This is a very big development, like I said, in this case. Bradford Cohen, you're the best. Thanks so much for coming on. Really appreciate you taking the time to break down every aspect of this. And like I said, I had so much to talk to you about before we were recording. I was like, we have so much to get to. Got to everything that I wanted to ask you about. Thanks so much.
Thanks, Ben.
All right, everybody, that's all we have for you right now here